Hi guys, it's Kathy. I hope you're doing well. Happy birthday, Tona. Listen, Tona, it's not that bad. You're just gonna be bored the whole time. This doesn't have anything to do with all the criminal activities that happened in Georgia. So what happens? This video was just released 5 days ago. What happens is when a lawyer breaks the law, it doesn't matter what the law is, they have to go in front of the disciplinary council um, to find out because they're a lawyer, you're not allowed to break the law. So they have their case of whatever they broke the law for, and then they have to deal with that. And then they go in front of the disciplinary council. So obviously, the Kraken broke the law and pled guilty. Well, now she has to come to Texas. She has to come to Texas and find out what her punishment is for breaking the law. So whether you love this person or hate this person, you're both going to be disappointed today. Yep. Just so you know, this whole hearing is going to disappoint you no matter what. No matter what you like or don't like, you're just going to be disappointed. Also, due to a malfunction of the courtroom video system, the first portion of the BODA proceedings on January 31st is only available in audio form. There's a problem with the video feed. So we just got audio. It's not really that long. It's just like it's only 20-some minutes long. Oh wait, no, I'm sorry. 30-some minutes long. So yeah, it's just mostly you're just gonna see a black screen with words on it. But I'm showing it. I'm showing it because it was a pretty big deal. And history, and I doubt anybody's seen it. They've only released the video a couple days ago, and it hardly got any views. So we're gonna watch it here. It's part of history, and then we're gonna move on to McBurney. Here we go.
I'm Bob Holmes, and I'm come to represent Ms. Powell in cases that require filing. So first in district court, and then we held the compulsory disciplinary hearings. And we believe that the compulsory disciplinary petition should be dismissed as a matter of statutory law. When you look at the definitions of compulsory discipline only applies when a Texas lawyer has been convicted of an intentional crime or is on probation of an intentional crime. So you go second to what is the definition of an intentional crime. The first step is a serious crime. There are some additions to serious crime. It's got to be a serious crime of this and this. But first, it must be a serious crime. And so then you go down to take the rules of trade procedure 106Z. The serious crime is battery, any felony, and this is not a felony. These were all misdemeanors. And then it says a misdemeanor involving theft, embezzlement, fraudulent or reckless misappropriation of money, stealing someone's money, taking some money from a bank, not paying it back, any of those acts, or attempting or committing conspiracy to do any of those serious crime acts. And I cited the court a case in my supplement to the supplement in Ray Caballero, which was a 2008 case, which was brought about before the code was amended, so the statutes there are different. In Caballero, it was 106T and 106Z, and those are now 106B and 106GG. So you've got to go back to look at what did Mrs. Powell plead to, not what she was accused of. Our case law, Supreme Court has said that you look at the element of what was pled to, not what was behind, what Ms. Powell's previous history was, or whatever else is going on. Well, Georgia Code, she pled to two misdemeanor statutes. The first, Georgia Code 16-4-8, and that's a conspiracy claim. You can't plead to conspiracy unless there's a subtext. So, and what did Mrs. Powell actually plead to that the conspiracy issue was 21-597, and that's a crime under Title 21 of the Election Code of Georgia. In quotes, that statute says any person who intentionally interferes with, hinders, or delays, or attempts to interfere with, hinder, or delay any person,
T-Moo House,
any other person in the performance of any act or duty authorized or imposed by this chapter, again, which is the Election Code chapter. And when you look at those specific things, what Ms. Powell pled to, there were none of the issues of what a serious crime is in Texas. There's no fraud, there's no theft, no marriage, no embezzlement, no misappropriation of money, property, or otherwise. And so, when you look at that,
no fraud.
again, the Supreme Court has said that you look at what Mrs. Powell pled to, not the facts of the underlying text. One more thing that I might bring to court's attention, the original indictment, which the bar now wants to argue, the accusation was dismissed. And I submitted an amendment yesterday, I believe the day before, adding as Exhibit 8, the order of the Georgia court dismissing the indictment against Ms. Powell. So basically what's before this court and what can be argued is what Ms. Powell does. If Ms. Powell has any questions, I'll be glad to answer. Any questions? Number 13, Citizen Attorney for Will. Your Honor, I did not offer any exhibits, and I didn't know whether you wanted me to offer those or not for that.
You don't need exhibits, not needed.
I will offer the exhibits that are in the second amended exhibit and list and the exhibits attached to that. Is the number, sir, is the number or the exhibits number? The exhibits run 1 through 8.
Yes, Your Honor. We object to Exhibit 4, which is a 1998-99 Georgia opinion of the Attorney General, as it's irrelevant because it's a Georgia, it's not binding, but also as are opinions by the Texas Attorney General, they're also not binding on the disciplinary proceedings, so we object to its relevance.
Your Honor, it basically, that exhibit basically states that this is such an insignificant crime in Georgia that when you get accused or indicted, the only response to her objection. Objection, or it stands on its face as an order of any other objections to the exhibits?
Specifically that it's non-binding and irrelevant.
The objection on the floor, 1, 2, 3, 5, 4.
I have a second objection.
I'm sorry?
I have a second objection. My second objection is to number 8, which is the nolle prosequi that was added to the second amended corrected list. For similar reasons, it's irrelevant in this case because we're talking about the plea and the judgment that Ms. Powell signed as guilty.
Well, Your Honor, that's an order of the Georgia court, that the courts in Texas, and I'm asked.
All the rule objection, all the 145.
And may I ask for a clarification of Mr. Holmes? Mr. Holmes, you had also asked that judicial notice be taken of all 8 of these exhibits. Are you reissuing that now?
I am asking the panel to do that because under our Texas rules, you have the right to do that because they are Georgia laws and are orders of the court.
You admitted copies of the Georgia laws?
Yes, I did.
All right, well, we'll take those judicial notice of the admitted statutes.
Thank you, Your Honor.
Right.
Thank you, Judge Crittenden. May I proceed? Okay. Something that Mr. Holmes did not address, but I would like to address, is how we got here to this compulsory disciplinary proceeding today. Mr. Holmes has argued in his answers as well as in his motion to dismiss that we're here because of third parties who submitted information to the bar in an attempt to, I think he calls it lawfare, but what I am here to do today and for this motion, the statute 801 of the compulsory disciplinary statute part 8 states that when an attorney licensed to practice law in Texas has been convicted of an intentional crime or has been placed on probation for an intentional crime with or without an adjudication of guilt, the Chief Disciplinary Counsel shall initiate a disciplinary action seeking compulsory discipline pursuant to this part. So I want to make it abundantly clear for the record, we are here because it is the position of the commission, the petitioner in this matter, that the crimes pled guilty to by Ms. Powell are intentional and serious crimes and therefore require us by statute to come and make this argument. Now, it's at the board's discretion to decide whether or not they believe that the crimes are in fact intentional and serious. But we are here because the statute requires our office to do so. And that is why we are here, not because they were the
serious crime.
Yes, sir. And that is I'll come back to that as my second argument.
But counsel, if you all did not think that that was the case, you'd not bring the case, right?
We wouldn't have the requirement by the statute to do so. And we do believe that they are, and therefore we must be here.
How does the crime pled to meet your definition of serious crime?
Yes, sir.
Barratry, etc.
Rule 1.06 GG of the rules defines a serious crime as barratry, semicolon. And this means the punctuation here to me is very important. Barratry, so as its own thing, any type of barratry, felony barratry, misdemeanor barratry, all barratry qualifies. Any felony involving moral turpitude. We've recently been here in the last several photo sessions talking exactly about that, whether something falls under a crime of moral turpitude or not. That's not what I'm here to argue today, whether or not the crimes are moral turpitude. Ms. Powell, in her judgment, specifically says these crimes are not crimes of moral turpitude. But then we get to the next, again, there's a semicolon, so next clause, any misdemeanor involving theft, embezzlement, or fraudulent or reckless misappropriation of money or other property. Involving theft, embezzlement, or fraudulent or reckless misappropriation. Those words are not defined any further than the plain meaning of those words. Theft has many different meanings in the legal field, in the civil field, the criminal field, and in the plain parlance. Right? Somebody takes your pencil and never gives it back. That is theft. That is the broad meaning of the word theft. The statutory language here did not give us further parameters, presumably because any theft by a lawyer, a person with power, a person with authority, a person whose mere words hold more weight than your average person.
What's alleged to be stolen here?
Voter data. So this is when we're going to get into talking about, if you will permit me to do so, the accusations. Now, I understand that Mr. Holmes is arguing that the accusations should not be considered here. And I will make two different distinctions. One, I will offer in a moment the accusations and all of my exhibits on my list. I think it is very important to note that the final judgment references the accusations. It specifically says, as indicted or accused. It's incorporated by reference because it's a lot of words. There are 6 counts, and each of those 6 counts lays out how Ms. Powell, I'm sorry, I'm speaking very fast, how Ms. Powell hired Strickler PLLC, paid them to go to Georgia, somehow gain entrance to the voter. Yes, sir.
Is in the Georgia statute, is the taking of data or theft or taking of any property, is that an element of the election fraud offense?
I'm sorry, will you ask the question again?
Sure. In the Georgia statute that Ms. Powell pled to,
The 64-8, is that what you're specifically referencing?
the 21,
Yes, sir.
is it 21-5, whatever, is taking of property or theft, is that an element that is required to prove election fraud under the Georgia statute?
There is, no, the statute itself, 21, the statute you are referencing, is particularly vague. What it specifically references is an intentional interference with voter duties. And so while the statute itself doesn't have the language of theft or a taking, that's exactly why we're arguing they chose to incorporate the accusation, because many different things could be held to be voter interference. As Mr. Holmes has stated, simply, which I disagree with, but simply having a polite chat with someone outside their office door that keeps them from attending to their voter duties could be brought under the statute. I argue with that a little bit because, like, again, there is an intentionality requirement. So if you're saying, hi, I live in the voter registrator or whoever she may be, unless you are intending to keep her from doing her job with election duties, that doesn't count. So I argue that the way the statute for that is written, and it's what she pled to, could have many different implications, which is why they specify that you have to look to the accusation or the indictment for the exact specifications of why that was pled to.
Do you have an opinion from the Georgia Supreme Court backing up that argument?
I don't think it's ever come to them, that specificity of argument. And I know that Mr. Holmes has also argued that she could have pled to taking of voter data, or she could have pled to theft, or she could have, but she couldn't because she wouldn't have. She tells you that. She says she specifically pled to these charges because they agreed that they weren't going to be crimes of moral turpitude, and she wouldn't have agreed otherwise. So we could be here 3 years down the road if there had been a trial, and maybe they had brought charges or convicted her of something different.
The council, they didn't do that. Explain to me in 21-2-597 where the text of that statute supports the argument you're making.
The statute itself?
Yes.
The statute is very vague and plain. It specifically only references the intentional interference of voter duties.
So the text of 21-2-597 does not contain the requirements that are in TRDP 106G2. Yeah, we're just agreement on that?
Yes, but I have to say yes to your question. But I also, if you may, to go off of, because all of these questions that have been asked to me, I want to make it also clear that whether or not it is an intentional crime or a serious crime, it is a compulsory disciplinary matter for the board to decide. It's not for a motion to dismiss.
Can I just understand you to say it can be intentional or serious?
No, it has to be intentional, and by intentional has to be a serious crime, or that is what we are here talking about, correct? In this particular instance, we're arguing that there are both, yes. And that you need both. Correct.
But if 21-2-597 is not a serious crime, then this is not a compulsory matter. Is that right?
That is not, it doesn't work that way. So it's kind of a rectangle is not a square, but a square is a rectangle. So that is the legal argument to be made for a compulsory matter. It's basically, there is a legal question to be answered by the board in a compulsory matter. So to say that we're here on, it's more appropriate that he's filing a summary judgment motion than saying that there is not a legal argument to be made. And there is a distinction there. There is a direct legal distinction there.
So I think, let me see if I can procedurally parse out your argument. Do I understand you to be arguing that the question on the 91A involves only the intentionality, and then the merits, if you like, are intentionality and serious?
Not exactly. I'm arguing that the 91A is saying that we as the petitioner don't have a legal reason to be here. And the legal reason is for the panel to decide whether or not there is whether the crimes Ms. Powell pled to are serious and thereby and also intentional, and that is subject to compulsory discipline.
And your position is that is the case.
Correct.
And how is that position based on the text of 21-597?
Again, because what is encompassed in what she pled to, again, as incorporated by the judgment. You have to understand, the record of conviction is what the Texas courts say we can look at. That's what the language in the rule specifically says. It says for a compulsory discipline, we look to the record of conviction. And there is Texas law, settled law, that says the record of conviction includes the indictment as well as the judgment. And presumably that is because, and especially you can see in these cases, in Georgia they call it an accusation, here we would call it an indictment. So you have to say, you have to get all the encompassing documentation, which is not always going to be held solely in the judgment. It's very similar to how this court does its orders. Sometimes we get an order that just says the petitioner's motions are granted and we don't get any further information. Sometimes you need that further information to be able to glean what the purposes of the arbiter means. And in this particular case, because the judgment specifically references the accusations, and the case law in Texas says the record of information is what to be considered, that also includes the accusation here. That's how we meet our burden.
This is case, let's start with the case law for just a second. How do you get to the indictment in light of Locke, Duncan, and Humphreys, which seem to strongly suggest that compulsory discipline is supposed to be a summary proceeding, that it's immediate, and that it turns on the elements of the crime per se? How do you, I assume you overcome that case law by saying that the record of conviction is an expansive term that embraces everything. Do you overcome Locke, Duncan, and Humphreys based on your conception of the breadth of the record of conviction? Is that right?
You phrased that perfectly. I could not have argued it better myself. I do, and to give you some further information on that,
how is that possible under Locke?
That's exactly right.
And Humphreys?
Yes, sir. In Locke and Duncan and Humphreys, if you look closer at what they are actually arguing, all of those involve crimes of moral turpitude, and they specifically talk about using the judgment only in so much as you are attempting to confirm that a crime of moral turpitude that is not per se, so has already been determined to be one, that is what you can look to determine whether a crime is a crime of moral turpitude. It does not, none of them stand for the premise that you cannot use extenuating other documents when you are looking to intentionality, which is what I argued in Mr. Herring's case, this last photo, as well as, in this particular case, including theft. And again, theft is so, I mean, when you say theft, the average person has a feeling about it. And if you said, your attorney.
Well, we're not going to decide this based on people's feelings.
I'm not, but I do think that the public policy argument is important in terms of why these three misdemeanors are carved out individually and not given a Texas Penal Code reference, not given a further legal definition, no footnote, no comment. They are meant to be taken as plain language of the statute.
Right, and the plain language of the statute doesn't have anything.
Of the statute that controls the compulsory disciplinary matter.
You refer to it as a rule. Sorry, I was confused. It's a rule, I'm saying. Right, so the record of conviction includes everything, and Justice Owens' concurrence, I guess. She said, hey, let's look at the indictment and let's get to the bottom of this. And the majority conspicuously didn't do that, and then the other concurrence, I believe, I know they put this sense, right? The other separate writing, for Chief Justice Heck's opinion, also didn't use the indictment. How do you square those opinions with the idea that we can look at the accusation or the indictment? Just that specific case.
So I will, which specific case would you like?
The one where you got 3 separate writings, and the dissent said, hey, we can use the indictment. The majority doesn't use the indictment, and the other separate writing doesn't use the indictment either.
Well, a review of this board's history will show you that the indictment has frequently been.
Okay, so a decision of this board can trump a decision of the Texas Supreme Court.
I think this board has broad discretion, and I think.
Can we have discretion to review a Supreme Court precedent?
I'd love to give you a full answer, which is the Supreme Court has made their decision. And it is for this board to determine whether they choose to agree with that or disagree with that. I've already explained to you how the position of the commission says that Locke does not stand for the premise that you can only look to that specific document, that it gives levity, it gives leeway for you to look at the record of the commission, which is more expansive, in the question of intentionality. And as I argued to Mr. Heron, because of intentionality, you need to know the facts to know whether this person did it intentionally or not. Sometimes the order and the judgment are not enough. And also, in cases of trying to determine whether or not something is that. This, too, I believe, based on my research, is a novel argument being made by the commission. I don't have any other case law that would tell us how this is supposed to go. What I can tell you is I've read Locke and Humphrey and all of the cases surrounding this, and I stand for the premise I've just given you. And additionally, can I give you just one small point about the conspiracy, specifically about conspiracy. Conspiracy for many different things has been brought in front of this board on many occasions. And in many of them, I'm happy to provide supplemental briefing if you want, the indictment was in fact looked at to determine whether or not the case qualified for compulsory discipline. I apologize.
My question is, assuming that the broader reading of record of conviction includes the indictment or accusation, then the charging instrument includes non-statutory information. So specifically facts surrounding the underlying offense. Are you saying we get to consider those underlying facts?
I think based on the reading of Locke and Duncan and Humphreys, to determine whether or not this case falls under a case of involving a misdemeanor involving theft, I do believe you can.
I'm trying to understand your argument. So you're saying the long line of cases is command to only look at the elements of the case only applies when you have a moral turpitude definition question?
I am telling you that that's what those cases say in all of their dicta. They are all specifically deciding whether or not the crimes pled or crimes of moral turpitude. They don't even get into the other issues surrounding the language of the requirements in Section 8.
But you can see that's just dicta, right? You just said it, right?
I said dicta and it was the wrong choice of word because the case matter. The case, obviously, we've talked about these three cases in the last 5 times I've been here. They are obviously very, very important. And that's why the whole case matters. They are specifically determining cases about moral turpitude. And we've already conceded, and the judgment states they are not crimes of moral turpitude. That's why these cases are only so helpful to us in this particular case.
Ms. Gates, you mentioned the previous cases that the board considered in the last ongoing session. My recollection is when we were looking at the charging instruments in those, we were looking at them in the statutory language of the offense. Is that correct?
That would be information I wasn't privileged to, nor is it, I don't know. I can't answer your questions. I'm not sure if that's what you ultimately
As far
determine.
as the exhibits that CDC submitted,
In this case or the last
in the
case?
previous case, you submitted the judgment, you submitted the indictment, correct?
Yes, sir.
And you urged us to look at that as the total record of conviction, correct?
Yes, sir.
And in those cases, we were looking at the charging instrument for the statutory elements of the offense to determine whether or not it warranted compulsory discipline, correct?
So my recollection specifically about Mr. Herring's case was that the intentionality requirement was what we were looking at in regards to the accusation. And so that is exactly what I'm arguing here essentially. In that case, we were able to use the accusation because we're not talking about moral turpitude. We're trying to get it fast to determine whether or not there's an intentionality. Here, as I've argued numerous times, the statute, we don't seem to be asking much about intentionality, and that's because the statute itself is the intentional interference. It's in the words of the statute itself, it's in the words of the name of the statute, so then we're not talking about that, right? It's not the same necessarily as Mr. Herring, but as in Mr. Herring, the record of conviction, which would include the indictment and the accusation, here are going to help us expand the statute, which only tells us about interference of election duties, which gets us nowhere to how it occurred, which in this particular case, and in many other particular cases, would significantly matter if, as Mr. Holmes argues is the same, Ms. Powell just stopped Linda outside her office. I don't think we'd be here. Because it would then be very difficult to determine intentionality, again, without the accusation, which is why you need the accusation here to get to the rest of the words of the statute. Our rules, which I do believe are codified in the statute in the government code, but our rules.
Right, this case, we used 15 minutes most of answering questions, so here's more time to give any conclusory remarks.
I think I have made, with your wonderful questions, the argument the best I can, because I think your questions have allowed me to give my argument. I would like to then ask that my exhibits be entered at this time. I can read them for you, or they are on my list. I also have a question. My exhibits for the response I filed, do I need to offer those into the record, or are they in the record as part of my record?
Whatever you choose to.
Okay, well then, for the sake of clarity, I will offer them as well.
What are the numbers of the
Yes, sir. Exhibit 1 is the accusation in Ms. Powell's criminal case. It is unsigned. There are two versions. So there is an unsigned version, which is Exhibit 1, and a signed version, which is Exhibit 2. I move to offer those at this time.
Your Honor, I object to both of those because they have been expunged from the record, so to speak.
What are the ones that are dismissed, or those that were filed for the plea bargain?
They're as incorporated by the final judgment.
Those are not as incorporated by the final judgment. They're standalone accusations, Exhibit 1 and 2. And I have not objected to the non-pro-tonque order, which is the right order in that case, not the previous order. And I believe that those should not be part of the record and should be struck from the record because those have been released from the record as per the order on Monday.
I think it's a
Whatever the exact event, that's the right to about.
no, it's nothing. It was an accusation filed for plea, for example. Is that what you're saying?
Is, I think in this particular case, we're pulling out a word that has a difference, but the same difference, because in this case, they don't have an indictment. I believe that their version of the indictment is in fact called the accusation. And if I may respond to this objection, or not? Yes, sir, but a lot of the accusations, despite what the court's ultimate determination is, whether they choose to look at them to prove the language of the statute, are still certified copies of what occurred and what Ms. Powell is going to do in this case. I'd like to enter Exhibit 3, which is the guilty plea assignment song. Exhibit 4, And I will say this is slightly duplicative because it's already the final judgment has been entered by Mr. Holmes. However, there is a final judgment and then there's an ending final judgment. And so my exhibit 4 would include both the original and amended.
If exhibit 4 is just the original, then I have an objection because, again, that is not a live order in this case, in that case. The live order is one pro order, which I have. And that is not one pro order, am I hearing correct?
I am offering the final judgment as signed beyond.
There's no conversation, let's transition
I'm going to Yes, sir. I also move to enter exhibit 5, which is my signed affidavit stating that Ms. Powell is the individual referenced in our petition and is licensed in Texas. Exhibit 6 is the Lake Hawthorne letter from the Supreme Court stating that Ms. Powell is licensed in Texas. And for the sake of this, I have petitioner's response, exhibit 1, which is the service packet attempts for the original petition. Here's my response, exhibit 1, so here's the response memo brief I filed. This is the exhibit attached to my brief. One of the exhibits, exhibit 1.
You reject that, Your Honor, again, that's not like being in the case. It was a signature.
Similarly, that's what the brief, my exhibit to my brief is struck from the record. Exhibit 2 is service attempts of the first amended petition.
Objection order, those two are the same thing, yeah.
I asked for clarity in the beginning whether or not the exhibits attached to the brief I filed would be part of the record without entering them, and you actually run my case, so I'm just trying to offer for completeness of the record. No further records, that's fine, thank you.
I hope it'll take that long. The law continues, in my opinion, to define the crime serious, intentional, as a crime of intentional and serious, and that's not what this way would say. This way would really say that in court, that it is appropriate, this way takes my statement, that it must be an intentional crime, and an intentional crime is defined by a serious crime. It's not a serious and intentional crime. And I think it's clear whether or not they're I'm just not trying another question, I'm asking myself a question, how does a crime get committed that's not intentionally committed? Well, you walk up somebody on the street and steal their dinner, walk in and steal their money. So the intentional is a broad definition that includes the items in what is defined as a serious crime. And I think the bar continues to confuse that, and I just want to put that out. I think the other issue that I think is very important, and I did not cite the statute, but in Georgia there is a similar statute of election code, Georgia Code Annotated 21-2-603, which I would ask for to take judicial notice of it too, since it's a statute of another state.
Councilman, that is judicial notice of the form section, that is in first.
Sure.
We have to judicial notice of the form section, we haven't seen that.
But
That's actually legal authority, it's still going to go, so I see that,
But that statute clearly states that threatening violence, that would be a serious crime. Willfully walks or attempts to walk avenue to court. Threatens violence, willfully prepares or presents any officer regarding a motor certificate, knowing deposits fraudulent ballots, knowing registers fraudulent ballots. And my point is, if Georgia and this House had intended for her to be to a crime defined as a serious crime in the state of Texas, don't you think we might have included that statute as opposed to the statute they included? Because the Georgia statute that Mr. Powell said, again, conspiracy is not a crime unless there's not a crime. We all conspirators, conspiracy, not people have lunch over here, don't like tonight. That's a conspiracy, but it's not a crime. So my point is, the specific statute that we now budget has absolutely no definition of one or two crime or any crime that is a serious crime as defined in statute of state Texas. And again, I'm disagreeing completely with the water's statement of the cases that the Supreme Court has said. You look at what the person pled to, not what he was accused of. That is not different in those cases. Caballero is whole case, but it is still live, it is still the law. And that was that the Supreme Court in that state case says specifically it is not an intentional crime, which is a serious crime. There should not be a case filed in Texas.
I think it was under an argument, though, that those were all will turpitude cases. And the court said we're just going to confine ourselves to a review of the evidence of the offense because will turpitude is less finite than the definition of theft.
They argue over whether or not one is found pledging one or two crime or not. Because that's our question for the court.
My question to you is how do you respond to opposing counsel's arguments that a command under lock, and that line of cases, we should only look to the elements of the offense, is combined only because those cases are moral turpitude cases. And the CC in its word is free to use different interpretation because this is not a moral turpitude case.
The issue there is you go back and look at the Caballero case.
Was Caballero a moral turpitude case?
Sorry.
Was the Caballero case a moral turpitude case?
No, it was a lawsuit filed on same sort of circumstances was filed. And the Supreme Court said in that case, this case should not have been filed because it is not an intentional crime because it is not a defined serious crime.
What was the crime in the case?
Sorry?
What was the crime in the case?
I have to look it up right quick. I can't recall that.
If you give some other reason on that, that would be helpful.
Okay. Thank you. Thank you for that.
Thank you. The first take recess now, because go back and consider motion, go back and we'll go back and at least 10 recess, so we'll come outside for a break. Then we come back, we'll take up the final cases, we'll find.
Yes, sir.
Audio sucks in that last part. Okay, so we got the camera back, but we can't hear. But it's okay because I heard. So Sidney Powell was brought in front of the Texas Board of Disciplinary because she pled to crimes in Georgia. They said that there is no action needed on their part because what happened in Georgia was not serious crimes. And the only way that they need to take any action at all, this disciplinary board in Texas, is if Sidney Powell committed serious crimes. Because she didn't commit serious crimes, they don't have to do anything. And she's free to go. And I shredded a whole chicken while we were watching that. And we watched silent movies. We shredded a chicken, we watched silent movies, and we witnessed miscarriage of justice. But let's go to history. Let's go to McBurney. We like McBurney. All right, this case, guys. All right. Hold on. Let's bring him over here. Unmute him and stop. Pause. This case. I'll fix that later. Man, okay. We all make really, really dumb mistakes sometimes. When we're drunk or when we're not drunk. I can tell you right now, the worst thing I've ever said in my entire life happened while I was drunk once. And I don't understand it to this day. I don't understand how, and those words came out of my mouth. I don't get it. I didn't do what this guy did. It wasn't even close. It wasn't even close to what this guy did. But at first you're going to be really mad at him. Rightfully so, based on what you hear. But just stick with it. I don't know if you're still going to be mad at him at the end or not. I don't know. All I know is sometimes we just say, sometimes we do and say things that we really are just way outside of our character. And, maybe we shouldn't be the rest of our lives. Now, the rest of his life, he's going to be known as what he did here. He did it in public. It's on the internet. I have it. I'm showing it to you. But maybe the rest of our lives don't have to be what we did at our stupidest times, So he did some stupid things. And I guess I should tell you right from the beginning, it wasn't a hate crime. It wasn't against the LGBT community. It's going to sound like that at first. But any person that was in that room, any group, could have been the Girl Scouts, it could have been the NRA, it could have been any group that was using that room at the time would have gotten this. It just happened to be a pride conference. So here we go.
Okay. Okay. Pronounce your last name for me.
Drabick.
All right. That's what I was going to say. So, Mr. Drabick, you are here from out of state to enter a plea in your case. For that to work in just a moment. Ms. Rutland, I hate to do this to you, but so Mr. Drabick doesn't have to be turning away from the camera all the time. Do you mind moving up to the witness stand? I forgot to mention that. Mr. Drabick, in just a moment, Ms. Rutland is going to put you under oath and then ask you a series of questions that I bet Mr. Tevis has already talked to you about. They're about your rights as a criminal defendant. She will share with me a little bit about what the state believes the facts of the case are, Then I'll turn to Mr. Tevis. He'll have a chance to share with me his thoughts about the nature of the case, information about you. You'll have a chance to speak if you want to. You're not required to say anything, but you have a right to allocute, as we say. And then ultimately, if I think there is a sufficient factual basis for the plea, then I will accept it and sentence you, so you'll know today what the plan is, okay?
Yes.
It's important that you answer all the questions asked of you truthfully and completely. It's also important that you let me or Mr. Tevis know if at any point you've got a question because someone said something that you don't understand. I suspect you'll understand things. It could be that someone says something that is different from what you were expecting and you want to, hey, wait a minute, I need to talk to my lawyer about it. We're not rushing through this process. So if at any point you need to speak privately with Mr. Tevis, or if you just got a question for me, pause things rather than saving it till the end, okay?
All right, great. Thank you.
All right. Ms. Rutland, when you are ready.
Thank you. Will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you may lower your hand. Will you state your true and correct legal name?
Ralph George Drabick III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I am 45 years old. I have a master's degree from Michigan State, and I also have a chartered financial analyst, which is equivalent to a second master's degree from the CFI Institute.
Okay, so you are able to read, write, and understand
Oh,
English?
yes.
Okay. Do you understand that you are charged with the following offenses? Criminal damage to property in the second degree motivated by bias or prejudice, and criminal trespass motivated by bias or prejudice?
I do.
And do you understand that the minimum and maximum for criminal damage to property in the second degree is 1 to 5 years, and for criminal trespass, it is up to 12 months?
I do.
Have you reviewed the charges with your attorney, and have they advised you about the potential minimum and maximum for each sentence?
Yes, and he did.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Brian Tevis, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
Not now. No.
Are you satisfied with his services?
Yes, absolutely.
Attorney, do you waive formal reading of the indictment?
Yes, I've reviewed with Mr. Drabick. We'll waive a reading.
Okay,
any
and do you-
defects for the
thank you.
purposes of this plea.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 2 years probation and conditioned to special conditions, but the court does not have to accept this recommendation, and the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
I understand.
Do you understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
I am a U.S. citizen, and I do understand.
Thank you. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to maintain or obtain employment.
Can I have 1 second on that one?
Yes.
It's a general list of things that could be affected. Not saying you can't do those things except for firearms. You definitely can.
Except like after assuming everything is okay.
Not exactly. Just wait.
They tell that to everybody and everybody around with their conviction. Could be affected. Understand your notice.
I understand. Thank you.
No problem. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 15 years in prison?
I understand.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
I am.
Have you ever pled nolo contendere or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Thoroughly, yes.
Do you understand that if you violate any of the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, I understand.
Do you understand that by pleading guilty, I'm going to read a list of rights that you're giving up, and after each one, if you could just say you understand.
Okay.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury,
I understand.
the right to remain silent and not incriminate yourself,
I understand.
the right to confront witnesses against you,
I understand.
the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
I understand.
the right to the presumption of innocence,
I understand.
the right to testify on your own behalf and to present other evidence,
I understand.
the right to subpoena witnesses and compel the production of evidence,
I understand.
the right to have the charges against you proved beyond a reasonable doubt,
I understand.
the right to appeal if convicted of these charges after a trial.
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights above and enter a guilty plea because you are in fact guilty?
Sorry. With respect to, this is kind of a hybrid. We're negotiated on the plea, and I did raise this with Ms. Rutland. We would ask the court to accept only the motivated by bias portion under Alford versus North Carolina. We would admit factually to the damage itself. I can go into more detail as to why we're asking it to be split that way. So if the court wants to hear that now or at any other time, I can explain why we would divide that up. But
Sure, I'll wait so you can present sort of more in a complete way rather than piecemeal. But let me play back what I think I heard. Mr. Drabeck is pleading guilty and admits guilt to criminal damage to property in the second degree, as well as criminal trespass.
that's correct.
Those criminal offenses, he's saying, I did those things, full stop.
Yes.
There are additional allegations about which I suspect I'll hear more from Ms. Rutland, that those criminal acts were motivated by bias, prejudice, et cetera. I'm familiar with the case, but we'll worry about that. That'll be part of the record. And the pushback is, and not in a negative way, is those aren't being admitted to. There's evidence of it, and Mr. Drabeck is, and I'll have a discussion with him, has decided it's in his best interest to plead to the indictment as it's written. The indictment's not being amended, but he is not admitting that there was a racial animus here or a gender animus or a sexual orientation animus, and he'll get to speak his piece as well. But there's not a disagreement that there is a sufficient factual basis for the actual elements of the two crimes, setting aside the bias piece.
That is correct.
Got it. Okay,
And-
good.
Okay.
You can add anything you want on that front, but I understand where Mr. Tevis is drawing the line.
Okay, great. We
We
do.
had discussed that prior to court as well.
Yes.
Yeah.
Yes. So, do you want me to just finish the plea or would you rather? make it-
You should keep going the way you were going.
Okay. How do you plead to the charges of criminal damage to property in the second degree and criminal trespass in the indictment number 24 SC 005057?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledges of the charges against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
I understand.
Thank you. Okay, if it may please the court, I will give a brief synopsis of the facts. On August 28th, 2024, the Starling Hotel contacted the Atlanta Police Department in reference to a potential hate crime. APD LGBTQ TIA plus liaison Officer Hayes responded to the scene. He met with Ashley Miller, a representative of Global Black Pride, who said the event was set up in the Sequoia room of the hotel with multiple vendors inside. Ms. Miller notified the hotel staff that the room had been vandalized. The items damaged in this incident include mannequins, sound bath bowls, costume designs, pride flags, tables, and trophies. Among the damage was a pride flag that had been defecated on. Officer Hayes then spoke with Denise Brabham, a member of the hotel securities team. She stated that she was informed by 2 security guards about an incident that occurred the night before. She stated that one of the security guards, Mr. Jamarian Roberts, was patrolling the conference room and checking the rear doors when he heard what sounded like someone inside the conference room. He then witnessed a male pulling up his pants and walking towards him. The male was instructed to leave the area. Ms. Brabham then stated that a second security guard was called later that night about an intoxicated male laying down in the lobby of the hotel. The second security guard escorted the man back to his room 709. Ms. Brabham also gave the Officer Hayes an iPhone 14, which was found in the Sequoia conference room with a business card attached to it. The business card belonged to a Mr. Ralph Drabick, who was also the owner of room 709. Officer Hayes then reached out to Mr. Drabick and asked about the events that had occurred. And Mr. Drabick stated that he did not remember what happened, but he was extremely sorry for anything that might have happened. He went on to state that he is not part of the community, but he does not have anything against them. He stated that he would do anything to make it right, but he did not deny any of the allegations. And that all happened in Fulton County.
Where's the Starling Hotel?
So he's getting charged, I think, with hate crimes. He was drunk. He walked into a room. He destroyed it. He went to the bathroom. It just happened to be the wrong room to do that in.
Oh,
188 14th Street Northeast. Is it Sterlington? No,
I'm
it's
not disagreeing. I
Starling.
never heard of it, whatever it's called.
I think it's
Starling.
Starling?
Yeah.
So it's on 14th Street.
Yes.
Okay. Okay. Anything you want to, well, I guess you need to tell me more about, you said it's 2 years probation is the state's recommendation, or maybe they
Yes.
negotiated, but you had hinted that there are some special conditions of probation.
Oh, yes. Excuse me.
I mean,
The special conditions include
you lose all your, well, not all, but you lose most of your inhibitions the more intoxicated you get. So maybe, Kelly, maybe you're right. Maybe deep down, that's the way he feels. I don't believe it, though.
restitution to be determined at a later date, to complete sensitivity training, and to provide a written letter of apology to the victims.
So I'm going to talk to Mr. Tevis in a little bit about how probation is going to work given Mr. Drabick's state of residence. I'm assuming the state, meaning your office, doesn't object to Mr. Drabick being supervised out of Pennsylvania, assuming Pennsylvania accepts supervision.
That's correct. No objection there.
Okay. This letter to the victims, how does that
Does anybody remember where Judge McBurney is? What state?
work? Who are the victims? Is it an organization to which he would address it, or is there a president of the organization, or how do you see that going?
Yes, it could be to Global Black Pride.
Okay. And that's the organization that had the Sequoia room.
Yes.
I know it was Black Pride weekend, but Global Black Pride rooms at the hotel, and in particular, the Sequoia room was their conference hub.
Right.
Okay. And is that something that Mr. Drabick would get to you and you get it to them? He gets to probation?
That's what I'm saying. It does, but like I said, the worst thing I ever said was one time when I was drunk, and I don't believe, like, I'm sitting here today. I don't remember what I said. Someone told me afterwards. There's no way I believe that. There's no way I think that. I said it. I mean, I have no reason to doubt that I said what I said. But I know me. I don't believe what I said. It had nothing to do with race or anything like that. It was just something way worse.
and they figure out how to get to Global Black Pride?
No, it can be provided to me and I will get it to them.
Okay.
Send it to me, I'll send it to her. You got it?
Do you have any victim impact statements or information from Global Black Pride or any of their representatives?
I do not. We have spoken with the victims in depth. They are accepting of Mr. Drabick's apology and his apologetic nature that he's expressed throughout this entire thing, and they kind of are understanding of that and ready to move forward.
Okay. All right. This hearing got scheduled on a little bit of short notice, and it doesn't look like we managed to get pretrial services here to run a criminal history.
Okay.
Your visibility may be more Georgia only rather than nationwide, but Ms. Rutland, did you find anything
Georgia.
about Mr. Drabick that would make him not eligible for first offender?
No.
Okay. And talk to me a little bit about why 2 years probation as opposed to more. How did you arrive at that?
We arrived at that conclusion of 2 years being appropriate because of Mr. Drabick's we believe that he was sincere and apologetic. We also received a mitigation kind of packet that included, we took into account his problems with potentially alcohol and just his willingness to cooperate and his, I guess, dedication to resolving this case. We spoke with the victims who agreed that that would be appropriate, and so that's what we went with.
Okay, so did you get pushback from Global Black Pride of only 2 years probation, not 10 years prison, or?
No, we didn't.
Okay, all right, thank you. Mr. Tettis.
Thank you, Judge. Mr. Drabick had run his own private national background check through a third party. If the court wants that, I have that, but I will state in my place that he has no felony convictions or any significant criminal history, if any. With respect to this case, and the reason that we're asking for this to be kind of a hybridized under Alford, there is no doubt that he was intoxicated, and this conference room at the hotel was locked from the front, but apparently there's a side door, another door that they determined was not locked. And I believe that Mr. Drabick just wandered in there. He has no memory of this. He woke up the next morning with no phone, no wallet. Somebody mailed possessions of his. He has no idea who. They arrived at his home address and he took them to a lawyer there who opened it, and that was his wallet and some of his items. But he has no memory of anything that night. He was in town at the hotel because his employer had something going on here as well. So they had.
And his employer is or was?
Yes, he's been terminated, but at the time, sorry, I'm moving that sheet. You can just.
Rabobank.
Yeah, spell that for me.
RABO and then bank, Rabobank.
Oh, sorry, here it is.
Rabo
Yes,
Diversified.
Rabo Diversified Services. And they were in town. They had a happy hour for the employees that were here. They had dinner, there were cocktails involved. And at some point, Mr. Drabick has no recollection of any of this, but he was found by the hotel to be intoxicated, apparently lying on the floor, and was his phone was found in the conference room. So there's no dispute about the damage, but we don't believe that there's any motivational bias. We believe that it was alcohol intoxication. As the court is aware, and in making an accommodation and moving our last court date, he's been going through like a very serious custody dispute with his ex-wife in Pennsylvania. He is in therapy and meets with a counselor about coping mechanisms and how to deal with these things in a healthier way. That's been ongoing before, during, and after this case. He, in his previous employment, was named as the DEI and coordinator for his office and had put on presentations for 20 or 30 employees about these issues. He shared in those meetings that he himself, being Hispanic, has received derogatory epithets directed at him and how he handled that. He has a member of his family, I believe it's a cousin, who was transitioning from her to him, and his family had some problems with that. And he worked with them to help explain how to approach that and have to have those discussions. So He is adamant that there was no hatred or animus based on gender, sexuality, race, any of those things. But there's no denying that he was intoxicated and the damage was caused. That is the reason that we're asking the court to accept the plea. We're negotiating on everything except that one component. And with that component, rather than being kind of a factual certainty, I mean, there's a circumstantial element that, as far as I can see, it's simply that, this was the event that was happening. It's not as if he was attacking somebody or directing any vitriol at them, but the items that were damaged happened to be in that conference room where he stumbled in, and that is where we are today.
So if this had happened this week, it could well have been an NRA flag that he went to the bathroom on.
Yes, Judge, that is the case. It was nothing about that group. And as Ms. Rutland said, from the entirety of this case, he has been extremely apologetic. This is, of course, like humiliating, embarrassing. He lost his job because of this. That was in September. One more thing that we would be asking of the court, the first offender statute does allow a ceiling on the front end. I've prepared an order and I have letters. He has had 2 prospective employers in January and March who said, hey, we're great. We're in this process. We want to extend this offer. The background check came back. You have this open in Fulton County. We can't offer you the job.
Michael, have you ever been to Comic-Con?
I also have a letter that is pending right now from 4 days ago that is offering him a position subject to a background check. These are well-paying positions. He's been in finance for a long time. Prior to this job, he was at Wells Fargo for 5 years. Prior to that, he was at Aquin Financial and Ally before that. He's in the banking industry and has been unable to work since the September termination from Rabo Diversified Services. And so we are asking that the first offender be sealed on the front end. I have no doubt there will be no violations. He will complete the terms and the special conditions immediately. And that is another reason that we asked the court and the state, thank you for accommodating us, to move this up from the May date. Mr. Drabik has been pressuring our office I need to resolve this as soon as possible. Can we get in? Because he's unemployable while this is pending. And so certainly, in addition to being apologetic and very remorseful.
Why only 5 years? Why don't you own it anymore? I'll buy stuff from you. Why don't you own it anymore?
Remorseful and embarrassed by his actions then. I certainly think that there has been enough punishment and reflection on his part that this is, something that would never be repeated, but he still does need to earn a living. And so we're asking the court to seal, pursuant to first offender, the records of arrest and the clerk's records as well. And I've prepared an order if the court is inclined to do that. I don't, in my discussions, I mentioned this with Ms. Rutland, and her response was that she had no objection to first offender. I don't know if you meant with regard to the sealing or not, but so I don't know if we're negotiated on that part, but I have the order.
Okay.
And the letters if the court would like to see them.
How is this going to work with Georgia and Pennsylvania and probation?
I don't think there'll be any issues as far as, he would still be on probation. So typically he would meet with probation. They would get his information. They'll do the transfer to Pennsylvania where he will be supervised. Should there be any violations, of course, he has to come back before this court. But
I didn't ask the question well. My understanding is that Mr. Drabik may need to be in Georgia for a little while to take care of things with the Department of Community Supervision. I don't know that, and maybe there are exceptions, but I know he has to get the police report and the indictment and $100. There's a set of paperwork that has to be filed. And because Mr. Drabik is subject to supervision of Georgia probation until the transfer, I don't know that living in Pennsylvania is okay until the transfer happens. We probably can engineer something to make it okay, but it may not be tonight is okay. I thought maybe you, given the pressure you've been receiving from Mr. Drabik, had already reached out to probation. I'm pointing to Ms. Simpson, not that you would have talked with her, but there are a couple of people who are responsible for ICOTS, one half of the country or the other. No, I think it's actually like A through L and then M through Z. So there is someone in DCS Atlanta who would be letter D, handling the process for your client.
So there's a couple ways. I have had in felony cases even done virtually where probation will meet with them virtually, or that I've also had somebody stay around until 2:00, go to DCS, and they'll do the input for ICOTS at that time, which we can certainly do before he heads back. And also the court can put in the order that he is allowed to leave the state. You know, he would continue to communicate with them and do what he needs to do, but he's not required to stay here. So those are the three ways that I've had it handled before.
Okay.
I've never, and I wasn't aware that we could do probation stuff on the front end before there was a sentence because they haven't input or intake his information. But
Yeah, for future reference, you can. It's not that they're going to say, great, now you're under supervision. Until there's a sentence, there's no supervision. But if you know going into it that this is someone who's going to want to reside out of state, then you can prime the engine, already provide the indictment, the police report, the $100, all that can be ready to go. And so all that's left is here's the final disposition. And then I'd assume there has to be that first intake session, which can happen today. I don't know when Mr. Drabeck was planning on going back, but I would encourage him to have as his next stop going down. It's 3 blocks from here. And you're here, you can help him.
And the indictment.
Yeah. And we can get, Ms. Nelson can get the final disposition done pretty quickly and email that to you so you can then get it to your client. I just am flagging this because we'll get the official word from Ms. Simpson, but it may not be so simple as, hey, sort it out when you're back in Pennsylvania. There may need to be a few boxes that have to be checked before Mr. Drabeck can leave the state. And I'm not suggesting that is a 3-week process, but we just need to make sure we coordinate this.
Okay. Could we put it in the order that he be allowed to return home? He will have to come back to collect the bond money anyway, so it's not a problem to come back if probation needs him. But I think today he drove through the night to get here in the morning and is planning to return because someone's watching his house and his animals. But
okay,
as long as
we'll talk about
probation,
right? We'll talk about what absolutely has to.
Maybe, but what if I told you that this guy got a room at a hotel, got drunk at the bar, went into the conference room, peed all over the wall? I mean, what if there was no flag in there at all? Then would it be the same, or would it be, I mean, you know what I mean? It's just unfortunate that the things in the room were in the room. But I mean, it was, gosh, it was a whole bunch of things combined, and it's unfortunate. I just feel so bad for him. I think, who knows? Who knows what's in his heart? No one knows. No one knows. Maybe the alcohol fueled what he truly believes, or maybe he was just too drunk. If there were no flags in the room, he wouldn't have went in there and did what he did. I guess, you know what makes me believe you? Just the part of defecating, because he did it on a flag. That's on purpose. I feel that part is on purpose. I don't know.
To happen before he goes, and I am comfortable having a condition that he can, while we work through the ICOTS, reside in Pennsylvania. But I just didn't want him to think he could run out the door, hop in his car, and drive away.
No. We would meet with probation.
Okay. So, Mr. Drabeck, you have not been able to work at all since you were fired, or you've had to work in a job that isn't your preferred job?
I haven't had any work since then. I've 15 years in financial services, and those were the firms that I was reaching out to. Not only banks, but other advisory firms.
Okay, so you've been living off of savings or the goodwill of friends or family?
Savings.
Okay. All right. How long were you the DEI coordinator at your previous job?
6 months.
Had you just gotten it, and then when you were fired, you also were no longer the DEI coordinator?
When I was brought on in March, the person that brought me on asked me if I would do that. Champion was the correct DE&I champion.
So you had only been at this company for 6 months. Got it. Okay. It was a new job for you.
That's right. They recruited me out of Wells Fargo.
Okay, so this was a improved opportunity for you. You were excited, paid more, or it was an advancement to go from Wells Fargo to this job?
I was happy to take the offer.
Okay. Then lose it.
Wasn't happy to lose it.
No, understood. You are divorced, or separated.
Divorced.
Was that driven at all by, alcohol-related issues?
No, this was 12 years ago.
Oh, and there's a custody fight now.
My daughter's 12 years old.
Okay, got it.
We divorced before she was born, or we split, I should say, before she was born.
All right. Is there anything you want to add to what your lawyer shared?
I just want to agree with what Brian was saying and just add to that I'm terribly sorry. I have no recollection, but I have a hole in my heart because of this, and I have a terrible feeling. And even with what Ms. Rutland had said about what I spoke to Mr. Hayes, like I couldn't believe what he was telling me. I was like literally throwing up and being sick. I didn't know if it was me, but what he was saying and everything that was going on, it just, everything about this just makes me sick. So I'm hoping that.
It's a somewhat remarkable event, whether it was a conference room that was, or a large space that had been occupied and
I think, Judge McBurney, he doesn't exactly believe it all. He's wise beyond his years.
festooned by an organization, or if it was just an empty conference room to use it as a restroom and then be awakened from a stupor in the lobby or wherever you were found. That whole process, forget about the potential hate element to it, is somewhat remarkable. That's why I asked a little bit about your divorce. Is this the first time that you have drunk to excess, or is this an issue? And here's why I'm pressing.
I understand.
I want to make sure we've got good conditions of probation in place. Because if something like this happened again and you're still on sentence with me, you'll come all the way back down to Georgia to get locked up, and you'll lose your next job, and you won't have helped your 12-year-old daughter or whoever else is important in your life. So if there is a need for treatment, and Mr. Tevis mentioned that you're getting counseling, I didn't press him on that because it's not his, it's yours. People get counseling because of relationships. People get counseling because of addiction and whatnot. I want to make sure we don't leave untreated something that causes you to do what you did just a few months ago. And not the hate part of it, you can't treat that. But I drank way too much. It was cocktails, it was dinner, it was after dinner cocktails. And you went to the bathroom in a conference room at a hotel on the floor. That's not normal. And you need to not do that again. And that may mean you need help. I want to make sure you get it.
So I've never had an alcohol related offense, never had a DUI. I don't know what happened that night. I don't know if it was a mix of things. I don't know. I wish I could tell you. I don't know.
Okay.
But it was one night, one incident, and I still don't know. I wish I had a better answer for you, but I'm not going to sit here and make excuses either. All I can tell you is that I enjoy having a beer socially, but I've never taken it that far in my adult years. I was a 20-something. I was a college kid. I did have to learn my limits at a young age.
Right. But we're a couple decades past that.
We are, and that's where I was going with that.
Okay. All right. So you don't think, apart from this unfortunate night that caused a lot of hurt for other people, that there is an underlying substance abuse issue?
No, I do not.
Okay. All right. Do you have any questions about anything Ms. Rutland has said or that I've said?
No question, just the concern about my being able to leave here, to get back to my family.
Okay.
It's the concern. I don't know if it's a question, but it sounds like Brian understands what needs to be done, and I'm comfortable with him and everything's done so far. So.
Okay. You're in good hands there. And we're going to hear a little bit from Ms. Simpson, who is with probation. She won't be your probation officer, but she is in the know as to what will need to happen today, the bare minimum of what needs to happen today or before you can leave. Okay. Ms. Rutland, you mentioned that we may reconvene on the restitution front. I hear that a lot from ADAs, and then we never talk again. Is there something actively in the works on this, or and Mr. Tevis just was anxious to take the plea, and so he's agreed, hey, I'm gonna give you the time you need to round out the numbers?
Yes, the representative from Global Black Pride is going and getting an itemized, detailed list of damages for me.
Okay. Do we have a ballpark so that I can have, I mean, maybe that we don't have to have a hearing because.
Guys, they have a ballpark. They have a ballpark. I think, hold on. Here we go.
There's documentation and the figures are reasonable. But if it's $10 million, then we may be back together again to work through, wait, where did those numbers come from?
The estimation that I have is 8,000 to 10,000. Right?
Okay. All right. But the people you're working with are trying to document that.
Yes.
You'll share what you get with Mr. Tevis, and I'm fine having the hearing.
Guys, he did $8,000 to $10,000 worth of damage that night, and damage to his reputation. But $8,000 to $10,000 worth of damage. Come on.
I just leaving that open. It's a little complicated, just where Mr. Drabick will be.
Right.
But he can always elect to appear virtually for a restitution hearing. That's different from what's happening today. Okay, thank you for that. Mr. Drabick, first offender, I'm sure you and Mr. Tevis have talked about it. I need to talk to you about it as well. It is primarily an opportunity that the Georgia Penal Code affords people who haven't been in trouble before. And that describes you. At least you haven't been caught before. You don't have a criminal history that would preclude you from seeking to use the first offender status. The benefit is, the one you'll feel most immediately if I sign the sealing order, is that the arrest, and it's not a conviction today, it's a sentence, but you have a first offender disposition. And that can all be put under seal. And if you successfully complete the term of your sentence, and it's really, that's a twofold use of that word, term as in the length of your sentence, but also the terms of, you do sensitivity training, you write the letter, et cetera. If you do all those things, then not only can things remain sealed, but you can get things expunged. And Mr. Tevis can help you with that. It's a second chance that we give people who are first offenders, and you qualify for that. The downside of first offender, and it's important you understand it, is that if you are a slick talker, but are withholding from your lawyer, most importantly, but from me, there really is an underlying issue, and weekends aren't good for you, and you may well, in the middle of the summer, get pulled over because you drank too much and this and that. You come back down here because there are new charges, then I don't know that I will, although if it's anything like this, I promise you I will.
All right, you should be able to hear me right now, but you can't hear them. There we go.
And in this case, it would be up to 6 years. Now, you get credit for however much time you had been on probation, but in my example, if we're together again in 6 months, I'd have 5.5 years to work with. And if what you did in 6 months is indicative of recklessness, not taking care of yourself, in any way related to disparaging people on the basis of race, creed, sexual orientation, et cetera, it would be a big chunk of the 5.5 years that I would say, this isn't working. Welcome to the Georgia Department of Corrections.
I understand.
Not a place you want to be. You are not built for that. I say that not to threaten you, other than I'm going to sound like a broken record. My concerns about you and substance abuse, you don't fit the profile of someone who's going to get arrested again. But you need to understand that if I'm reading it wrong, and you are, there are messy repercussions in the first offender situation. Do you understand that?
I understand.
Okay. Understanding the primary benefit of first offender, but the potential risk of first offender, do you want to be sentenced as a first offender?
Yes.
All right. Your offered plea, as I understand it, but I want to hear it from you, is not to the fact that you damaged property, that you defecated in the room, that you're in a room you weren't supposed to be, et cetera. You admit to all those things. You may not remember them, but you're not saying wrong guy or anything like that. Your phone with your business card taped to it in there. You are admitting to all that. You are saying, but I don't agree with the state's contention that those crimes were motivated by hate or bias.
That's how I feel. Yes.
Okay, got it. I will accept your plea in that context. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means that you've understood everything we've discussed. And if you didn't, and I saw you do it a couple of times, you took your lawyer aside and had a little back and forth with him. Do you agree with that?
I agree with that.
All right. I'm sentencing you pursuant to the Probation Options Management Act, which in Georgia at least means that if you have a minor probation issue, let's say you missed a meeting with probation, you don't have to come see me. You and probation will work that out. I don't know how that works in Pennsylvania, but if you are in Georgia, that's how that'll work. I will not set any restitution at this time. On count 1, which is criminal damage to property in the second degree, I'm sentencing you to 3 years of probation. Count 2 is 12 months of probation. Those will run concurrently with each other, meaning at the same time. Special condition number 1 is that you complete a sensitivity training course. Number 2, that you write a letter of apology to the Global Black Pride organization. You'll get that to Mr. Tevis. He'll get it to Ms. Rutland, and she'll get it to the leadership of Global Black Pride. And then number 3, I'm adding, you will submit to a drug and alcohol abuse evaluation. And if that counselor or medical professional recommends any treatment, then that treatment will become part of your probation. I'm extending the probation a little bit longer than what was negotiated because I think it better fits what this case is all about. I'm adding that additional condition just to make sure we're backstopping. Life is complicated. You have had a stressful life over the last few months. And I just want to make sure if one of the ways you manage that stress is to just use anything to excess, that you've got a treatment program in place to protect you and the people you care about. But it may well be that you get that evaluation and they say, other than this horrible misstep, you don't have any issues on that front. And then there's no treatment. You don't need to worry about it, but you'll know you've had an evaluation where an expert in that field has had a chance to take a look at things and say, you have a good self-restraint in this space. Okay. Mr. Tevis, I am open to sealing things. If you could email to Ms. Nelson a Word version of the sealing order, I will take it from there because I understand the state does not oppose sealing things at this time. And it makes sense, Mr. Drabick, if the goal here was to grind you down, then it would be, let's send you to jail. If you're not going to be in jail, you might as well be able to provide for yourself and your daughter and other people who depend on you. You probably could have flipped burgers over the last few months, but you have a skill set that you're not able to rely on right now because these charges are open and a background check displays them. I'll tell you, if you had been charged with stealing from your employer, I wouldn't want anything sealed, even though it's first offender, because I would want the next employee to know, wait a minute, you may not want him in a position of trust. He can clean the floors, but he can't be near the drawer that has the money in it. But that's not your situation. Ms. Rutland, do you have, one more thing. Mr. Tevis, is it all right if someone in my office signs the indictment on your behalf?
Yes.
Can we sign for you, Ms. Rutland? And Mr. Drabick, instead of handing papers around these days, we e-sign lots of things. Can we electronically affix your name to the indictment indicating your first offender semi-offered plea in this case?
Yes.
All right, we will do just that. Ms. Rutland, did you have anything else?
No.
If you do sort out restitution and it's contested, just let Ms. Nelson know and we'll figure out a day for a hearing. If it is agreed upon, then an email copying Mr. Tevis to Ms. Nelson saying, here's the amount and it's payable to, I'm happy just to amend the sentence. We don't need to drag anyone into court. I'll amend the sentence and that'll become a condition of your probation, Mr. Drabick, that you pay that restitution. Restitution, unless it's negotiated, is never due immediately. It's pay as you are able. And you may have some debts that you've accumulated over the last few months, but you also are going to be going into an industry where I know you don't make minimum wage. So you'll need to pay that restitution. Another reason to give you a little more time on probation, because you can pay it over time. I don't have an ability to enforce payment once your sentence is done. So that's another reason to, in my mind, extend probation a little bit. So anything else, Mr. Tevis, on your side?
Your question. Mm-hmm. And I must have missed this part too. You said you were extending then I heard the alcohol abuse class. Are you extending the time of probation?
I gave him 3 years probation.
Okay.
3 years on the felony, 12 months on the misdemeanor, running them concurrently. So yes, I am extending it.
And his question then is, if he completes if he pays the money back and does all those things, is there an opportunity to terminate it at the 2 years?
So what I'll do is set a behavioral incentive date of April 26th of 2027. That's 2 years from today. If you've paid.
It's just a tiny glitch in the system.
Judge,
Hey, Ms. Rivers, the podium dropped for some reason. Everything else was still on. What was the last thing you heard?
I have no idea what that would be like to be in the middle of, cameras being on you and everything, and you're talking, and then poof, no sound.
okay, you said that's 2 years from today. If you paid and then it went silent.
Got it. Wow. All right. Sorry about that technical glitch. All I was saying is that if Mr. Drabick has paid his restitution, everything else has gone smoothly, then I am open to probation, whether it's coming from Pennsylvania or Georgia, petitioning me to close the case out early. But I won't be interested in hearing about that until we've hit the 2 year mark. And then we might have had some pleasantries beyond that, but we don't need to repeat those for the record. Anything else, Mr. Tevis?
I know the court has said you will incline to sign the sealing order, so I don't need to go into that, but just in purpose of the record, I meant to say also that regardless of his record, the GCIC being sealed, the public still has access because, of course, there was a press release. This is in the news. It's on the internet. So there's nothing we can do about that. That may still affect him, but that access for the public's interest is still out there.
Sure. No, a burden you're going to bear forever, Mr. Drabick, in this day and age is that there are 2 background checks employers do. They look at your criminal background check and then they go to Bing and type in Ralph Drabick. And lo and behold, there's this thing.
Yep.
And then they go to Bing. How many of you have used Bing this week?
And you negotiate that how you negotiate it, but that's not a criminal charge. Is clearly drop dead in your industry if they run your history and there's open charges. That will be sealed. But Mr. Tevis makes a good point. A burden you bear for what you got involved with is that it's still findable. It's just not an open case. So that's what
I took it personally. It hurt my feelings, the slow death of Internet Explorer. It just hurt my feelings because we were together for so long. Like I'm older than Internet Explorer, so I got to watch it become a baby and grow into full adulthood. and then just die. And it hurt my feelings when that one went away, let me just say. But that's how life goes. Google it.
Where we are. Let's hear from Ms. Simpson, because she's going to give you some guidance on the steps you need to take before you leave Georgia on probation.
When you're done, I need your address and contact information. Since, given the timeline that you have given, you need to contact Chief Lee today, meaning as soon as you leave here, because there are some steps, just as Jeff stated, that the process that she does before you can leave the state, and you are not permitted to leave before she gets everything that she needs from you.
Speaking of, OJ is next. Oh man, the people in OJ, I'm trying to remember. I'm pretty sure I got the years correct. The people who we're seeing next in OJ, they had Netflix mailed to them. You know, remember when Netflix came in the mail? Oh, that was so good. You could just return it whenever you wanted to. It came in its own little envelope, and you could get online and you could create a queue. Man, I thought if I wouldn't have, the first part might have been a little boring for people, but it's history. You know what I mean? Sidney Powell is American history. That's just who she is. Yep, I did that. I did Dewey Decimal. Yep. All right, guys. I loved Blockbuster. And the 50-cent charge they would charge me when I didn't rewind. Be kind, rewind. Nah, take my 50 cents, you do it. I don't have time to rewind it. Then I bought one of those little race cars that flip up and you put the tape in and it just rewinds it for you. I never used it though. I'm still like, nope, take my 50 cents. And then charge me $3 for candy. Oh, and you could go in and just watch movies there. Walk around, watch movies. And then the back room. I should have got a job at Blockbuster while I had the chance. Instead, I was serving tables. Red Lobster. That was when I worked at Red Lobster. Oh, yeah. Red Lobster. You know why I got a job at Red Lobster? I'll tell you why I got a job at Red Lobster. They had these huge strawberry margaritas, lobsteritas, I think they were called. Okay, but that's not why I got the job there. They had these huge lobsteritas, and if you bought one, it came with like the beads you get down in New Orleans. Come on, give me the word. Mardi Gras. They had like the Mardi Gras beads with a lobster attached to it, and you would wrap it around the glass and hook it on the side. Those beads, I loved them so much, and the drink was delicious. That's why I got a job at Red Lobster, and that was rough. I'm telling you, working at Red Lobster was rough because they didn't want you to leave the kitchen unless you had 5 plates on the huge trays. And Red Lobster plates are like this big, and they're real thick and heavy. They're not like they're very, very platey plates. So you had to carry at least 5. They wanted you to have 5. That way, food is always going out to the kitchen. You have your little tray stand in one and this huge tray in another. Drinks were easy, although I did spill one on a 1-year-old, but that's besides the point. The mom, I'm sure, has gotten over it by now. Maybe she was really pissed that day. But anyway, this poor guy's going to have to pay. It's probably going to be bumped up by then. $12,000 worth of damages. He's coming back here to Pennsylvania. I'm going to track him down. I did work with a dry spock, but they're not related. Platey plates, like real thick, real substantial plates, not these little thin ones that break when you drop them. You could throw that plate at the wall and the wall would get hit. The wall would just crumble around it. But yeah, the biscuits are so good. I have Red Lobster biscuits in my freezer right now I got from the grocery store. And I don't want to make them because I'm scared they won't taste good. I'm scared I made a mistake of buying them. I mean, all right, that's all I have for today. No, thick, not thick, thick. Oh, when the kids started using that word thick, THICC, they absolutely hated it when I said it. They hated it. This was before cringe was cringe, but I was cringe. I love when they make up stuff and they think I'm not allowed to use it. I'm too old to use it. Please. You're getting older every day, children. You'll find out. All right. OJ's already set up, so we'll pop right over there. Bye, guys. Get ready for OJ. Oh, get ready for OJ. We're almost done with Rosa. We're almost done. I don't know, those kids. Yep. No cap. Bye, guys. Maybe my outro will play today. What do you think? Think it'll play? Nope.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's life.